Hi, Chris. How are you?
I'm good, Maya. How are you?
I'm fine, thank you. Very happy to see you. This is your first time on this show, and I can't believe that it's only now, only that you're appearing when we've known each other for a pretty long time now, and we chat every now and there. So it's very nice to see you here finally, Chris, and thank you for taking the time. I know you're a very busy lawyer, but today we wanted to talk about what you do and especially appellate work because this is what a lot of people know you for. And I'm sure a lot of people want to know what is the Chris way of doing appeals and your approach. But before that, maybe I'll just start by having you introduce yourself and then we'll get into appeals and your approach to appeals.
Sure. Well, hi everyone. My name is Chris Sewrattan. I'm a criminal trial and appeal lawyer in Toronto. Perhaps the most unique thing you'll take away from this is that I'm one of the few lawyers that works with my sibling. So I work with my sister, Ashley Sewrattan, and our firm is called Sewrattan Criminal Lawyers, where we do trials and appeals.
All right. And so talking about appeals, Chris, so let's focus on that. I know you also do trials, but appellate work is really what I think a lot of people know you for. So what is your approach? How do you work on an appeal?
Right. My approach just generally to appeals is like anything in life, where if you are good at it, you can explain it in a simple way. And so with these appeals, what happens is, as the appeal lawyer, you're given hundreds of pages of transcript and asked, make something out of that. And so your task is to decant it and simplify it, find some errors from the judge, put it in the context of the trial, show why it's a compelling error, why this appellant, why this guy got railroaded, why he got an unfair trial, make the court feel something. And once you've done that, then give them the legal pathway to remedy this. It's easier said than done. And what it
Yeah.
requires is an intense understanding of the facts and the law, and then just distill down to its core so you can tell a very simple story and write as short of a factum as possible.
So, but this is the most challenging part, right? It's because you're getting, as you mentioned, hundreds and hundreds of pages, and sometimes it can be even longer, especially we're talking about a very long trial. And that's the challenge, right? It's trying to find what is really the core of what is essential to your argument and all of that information. So, what strategies do you use, though, to do that?
So different strategies and different processes.
Hmm.
So initially, when you're just getting the file, you're looking at where is an error most likely to happen.
Right.
So if it's a judge alone trial, you're looking at the reasons for judgment. That's where you're likely to
Yeah.
find the error. If you're looking at a jury trial, you're looking at the charge to the jury. After that, whether you find grounds or not, you keep moving on. You look at pretrial motions. After that, you're looking at the transcript now. So now you're getting deep. And you'll read the whole thing. You'll have to read it many times. But during your first run through, make sure you're taking note of any objections and mid-trial rulings. Because again, that's an opportunity
Hmm.
to find an error. And then the last bit, you're reading the rest of it for understanding and such. But in terms of finding a ground, that's your Hail Mary, right? That's you finding improper cross-examination or the Crown eliciting inadmissible evidence, something that you really have to know the law cold for, and you won't see it unless you know that that kind of error exists in advance.
And well, it's not just well the law, but including also procedure, right? Like you also have to understand objections and what is an appropriate objection or not. So I mean, really, it's a good opportunity for you to get better at the law, but it also requires you to be good at the law as well. Um, but then, if we're talking about jury appeals, because you did mention the distinction. I guess it's obviously easier when you do have reasons because you can see the reasoning why the judge came to a decision most of the time. Sometimes that's the issue, right? Like you have a
Right.
decision, but you don't really have it very well explained why. But in jury trials, you don't have that. And you're going to the charge. But then the issue that we have with the charge is that there is this conference that we have before we get there where all of these issues are discussed. So uh, that's also another challenging issue. So, how do you deal with that point, Chris?
Right. I actually think that jury appeals, I mean, the appeals are difficult to begin with, so
Yeah.
don't get it twisted.
Hmm.
But jury appeals are easier to do as appellate counsel than judge alone trials. The reason is because there's something called the curative proviso. We're jumping way ahead, but that's where the Court of Appeal says, look, yeah, there was an error of law here, but we're still going to dismiss the appeal. You still lose because it didn't matter. The judge didn't rely on this inadmissible evidence, or the judge didn't rely on the prejudice created from their error. With a jury, they can't really do that because juries are sworn to secrecy. It's a criminal offense to get into their deliberative process. So nobody knows what effect, you can't trace the effect of an error on the jury's
Hmm.
reasoning. So half the battle's already won for you. All you got to do is find that legal error and tell the court, we don't know what effect it would have had. We can't say it had no effect. So that's that. You were talking about the jury conferences, and I'll address
Yeah.
that directly. Who cares? That's the short answer. That's all argument. Oh, defense counsel had a chance to look at it. Who
Yeah.
cares? There's a
Oh,
judge.
but that's what they say, though.
Yeah, that's just reason padding.
Okay.
I mean, what the law actually says is okay. If the defense counsel doesn't raise an objection, it's an indication for the Court of Appeal as to how serious the prejudice was from this legal error, right? Like if it's that bad, why didn't you say anything?
Yeah.
I get it. But at the end of the day, there's a judge, right, who's been appointed by the government, who gets paid a lot of money, who is the gatekeeper of trial fairness, and they messed up. So it's not enough to say defense counsel messed up by not objecting. At the end of the day, the question is, did this guy get a fair trial? Yes or no? The answer is no. It doesn't matter who didn't do their job
Right.
properly.
Yeah.
Job of the Court of Appeal is to fix it.
Yeah. No, I totally agree with you on that. And at the end of the day, I think what matters is if there was a fair trial, like you said, as opposed to who is responsible for what and who did what they were supposed to do or not. So I agree with you on that. And when it comes then to trial, so what I wanted to know from you though is what is your view? Because sometimes there are lawyers who say, well, if you were the trial lawyer, it's better that the appeal be done by another lawyer, not the same lawyer. What is your thoughts on that? Do you agree with that, or do you do your own appeals or your own trials?
Right. If you lose the trial, so you are the appellant, your client is the appellant.
Hmm.
My view is that a different lawyer should be doing the appeal for many reasons. The easiest one is that you need fresh eyes on the case, but also we as humans have a habit of locking into our mistakes or trying to justify them like, yes, I did this and maybe it was wrong, but here are the circumstances. And that might be valid, but on appeal, you need a fresh lawyer to take a fresh look and say, you know what, maybe that was a miscalculation and maybe this case can be thought of a different way, that the failure to think of it that way was an error of law. So get someone else to do it.
Okay. And Chris, so when you're getting these transcripts, because it's obviously, I mean, the disadvantage when you're not the trial lawyer is that you don't know the case. I mean, maybe you know a little bit because you were in touch with the trial lawyer while they were doing the trial. But sometimes you can get a case where you have no idea, like a client is calling you, you don't know who the lawyer was, you don't know what the case was about. And then you have to discover, like, you have to read all these transcripts, and it's very time consuming. So, how do you organize yourself to do that? Like, what do you do? Because I think that's what's scary for a lot of people, especially new lawyers who want to get into this type of work. They get overwhelmed by the volumes of transcripts that they have. So, what do you do? Because your experience, you've done this a lot now. What is your strategy?
So we'll get to strategy in a second. If you're a junior lawyer looking to do your first appeal or to learn about it, you should be looking at case trials that were 1 to 3 days long. Ideally one witness cases or two witness cases in
Mhm.
which the second witness is the defendant. Don't be doing a week-long sex assault because you're just not equipped for that and you're going to make a mistake. But to directly answer your question, when someone approaches you, if you can't get a hold of the trial lawyer to get the relevant details, order a copy of either the information or the indictment. In Ontario, it's quite easy because a lot of things are digital. Even if they're not digital, the clerks, I don't know what they've done around the province, but they're very fast now at getting you these documents. Once they send it to you, you can see when decisions were made. Decision on pretrial motion made, the indictment will be endorsed on such and such date.
Mhm.
Then you can write to the court and ask for those documents. If they don't provide it to you, you can either try to get the transcript created or for free, you can request the audio recording and listen to the judge's words on the judgment and then try to formulate grounds of appeal from there.
Okay. That's really good advice. And then, um, so one thing that I also wanted to ask you about is because you do have experience doing both legal aid appeals and private. I know now you're doing more private appeals as opposed to legal aid, but you do have that experience and you do know how legal aid works when it comes to appeals. So if you can just tell us a little bit about the difference and again, what your approach is when it comes to um, a legal aid appeal versus a private appeal.
Right. Legal aid is not nearly as generous with granting certificates for an appeal. It really is a privilege to get a legal aid certificate for appeal. It's not like a trial where if you meet the criteria of jail and income, that you're going to automatically get a certificate. The process is lengthy. You need to, well, typically legal aid wants the trial lawyer to write what's called an opinion letter. They'll issue a certificate. Often you'll get a client calling you up saying, "Hey, I want to appeal this case. I have a certificate." And they're right. The thing is, that certificate, I think it's for 5 hours, and it's for a lawyer to write a letter expressing an opinion on the merit of the appeal.
Hmm.
Even if you write a letter and in your heart of hearts, you think this appeal has legs, it's going to win.
Yeah.
Legal aid will then send it to a opinion letter committee, like a committee of lawyers, who will review that and they will determine whether or not to issue a certificate. Only then might you get a certificate for the appeal, and then you can, you know, go start doing your thing.
Right. And so that's something that can be confusing sometimes is the certificate that you get to write the opinion letter is not the actual certificate for the appeal. So there's still another step that will be up to legal aid, and then you'll get that. So there's no guarantee. Whereas on a private appeal, it's different. Now, the work is still the same, right? Like otherwise, the approach is still the same to how you actually work on the appeals. But then one thing that a lot of lawyers, especially those who are new to appeals or who want to get into appeals but are hesitating, one of the things that they always worry about is, well, how do you balance that, especially like someone in your case where you're also doing trials? So it's not like you're exclusively an appellate lawyer, you also do trials. So how do you balance that, especially that appeals require a lot of readings? So how is it working for you, Chris?
It works well for me because I'm experienced now. So I can pump out an appeal factum start to finish in less than a week.
And
But
how long is your factum?
I try to make them as short as possible. So at the
Okay.
at the Court of Appeals level, you get a maximum of 30 pages.
Right. And
Mine
yours
are
are?
typically between 10 and
Oh,
let's say
wow.
20. It depends how many grounds of appeal there are, but if there's one or two
Hmm.
grounds of appeal, it should be 10 or 12 pages, right? Because remember what I started with, it needs to be simple. And it's only going to be simple if you know it in and out. If it at the summary conviction level, which is where more junior lawyers would start, the page limit is 20, right? Anytime there's a page limit, you don't want to hit it. You want to come 1 or 2 pages max below it, so 18
Okay.
or 19. But it really depends on how many grounds of appeal you have. Now, want to say two important things about legal aid appeals that are, I think, unique to myself. I learned this in law school. I went to Osgood. I was taught by Professor Alan Hutchinson. I took a legal ethics in first year, and I took it again in second year as a seminar. His view, which I have adopted since a student, is regardless of the retainer amount,
Yeah.
if you take on a case, my personal non-law society binding belief is that you have an ethical duty to do the best job possible
For the client.
for the client,
Yeah.
right? So an appeal, I don't really care. I mean, I care financially, but I don't care in terms of effort I put in, whether it's a legal aid appeal, a private appeal, Elon Musk is paying me,
Hmm.
unlimited resources. I'm going to put the same amount of time into
Yeah.
it or the same amount of effort. That's one. Two is if someone, if this is a serious case and someone's coming to you with a certificate for legal aid for an appeal and you're willing to take it, there are three things that they want that all require the same kind of work. They want to win the appeal.
Yeah.
They're going to want bail while they await their appeal hearing.
Hmm.
That's called bail pending appeal. And they're going to want the opinion letter certificate or the opinion letter that will get them a legal aid certificate. And all three of those things require you to write something explaining why this person is going to win the appeal.
Yeah.
That's how you get bail. That's how you win the appeal. That's how you get the certificate. So I front end my work. When a client approaches me, I really, I read as much as I can about the appeal. If they have the judgments, I read that. If they have the resources to get me the transcripts, I'll read them slowly and carefully. And I will write the best possible application for bail pending appeal. I basically write the factum at that time.
And I can confirm that because as you know, like when I was asking for, a precedent for a legal aid opinion letter for an appeal, I asked you and it really is a factum. So it's
Yeah,
it's really intense.
it's very intense. But so then you do that, you get them out on bail. Then I'll write the opinion letter. And it's just a lot of editing and transferring, but a lot of the heart of the analysis is written. Boom, now you're going to get your legal aid certificate. And then now you've turned to the appeal and you've done most of the work,
Hmm.
right? Legal
Yeah.
aid's only going to give you in Ontario, they're only going to give you 37 hours anyway, right? It's really not consistent with what an appeal requires, but that's perhaps a different conversation. The point is, you've done a lot of work in the beginning and it's going to pay off at different stages. Um, and then, of course, even when you get to the oral hearing, all that research and stuff is going to come to play again.
Yeah. Now, the challenge, though, is that because you did mention that clients, what they want is they want to get out as soon as possible. They want to try to get bail pending appeal. And especially if you were not the trial lawyer and you don't really know much about the case, you have to order the transcripts or you have to order, the decisions and you want to know what's going on. And that takes time sometimes. Like you can expedite, but still there is a waiting time. But how do you then balance that with the client who's just constantly calling and who wants to get out as soon as possible?
I'm realistic with them from the start.
Hmm.
In the past, when I was junior, like, I
Yeah.
just take the calls and it's annoying, but understandable. Now I'm just very straight up with them. Like, I'm an experienced lawyer. This is how it's going to go. I don't have many answers for you until I get to the reasons for judgment. And frankly, I do not do bail pending appeal on legal aid anymore. I haven't for many years. So they're paying privately. So the more they want to call me, okay, but there's an invoice coming. And once the invoice comes, they pretty quickly learn to ration their phone calls and inquiries.
Yeah. All right. And Chris, I do want to, and I am mindful of your time, but I do want it to touch upon one thing, and that is your practice, because you did mention that you do work with your sister, and which is rare. We don't, we have some family settings in criminal law. It's not like there are no firms where family members work together, but I mean, a brother and sister, we don't have too many firms where it's really the two brother and sister who are the partners in a firm. So if you can just tell us a little bit about how you and Ashley work together and how is it going? Do you guys fight a lot? And I'd be fighting a lot if I was with one of my siblings.
I guess for context, maybe this is too much, but you should understand there's four of us, there's four kids, and me and Ashley are the middle children.
Mhm.
So we've always kind of been similar in that respect. Like we're both the nerds. Obviously, we both like law. We both ended up in criminal law. So we're already similar. And no, we never fight, which is surprising.
Yeah.
We might disagree from time to time, but it's fine. And what's great about it is we don't like, you go to the office and it's, hey, how are you? And there's a big wind up to whatever you're going to ask. And we're brothers, sisters, so there's none of that. I
Yeah.
just even will just send her a voice note on WhatsApp, straight directions, right? Or
Yeah.
straight question or whatever. And she's good with it. And she just might respond and ask me like how my kids are doing, right? Like
Yeah.
nothing about work. It's seamless and easy. We have in the past, like we're talking about maybe 5 years ago now, gotten into disagreements. And instead of hashing it out like you would in an office setting, I've had like my dad call and be like, what are you doing? Ashley's complaining about this and this. And so sometimes in the past, we've gone to our parents to settle disagreements. But again, that was about half a decade ago. And it's pretty seamless now. It's a great thing, I think, for me at least, and her to work with our sibling.
And you both do appeals and trials, right? Or is it divided?
No, so the way we operate our business,
Hmm.
although we do take some legal aid, at this stage going forward, we're trying to take less and less. And so the point is, we do a lot of private retainers, and if this person is hearing bound, so trial or appeal hearing bound, the retainer contemplates that they'll be hiring both of us. We work together.
Okay, so you're always partners. You're always, so you work together on many of the files.
Yeah.
Okay.
I can't stress, not just because it's Ashley or because I have some seniority now, the importance I'd like to stress of having a second person with you. Doesn't have to be a second lawyer. It can be an articling student, summer student, high school student, just someone else there to bounce an idea off of, or who might notice something that you'll miss, is very important for active litigation, right? Like going to trials and doing pretrial motions or doing an appeal. You don't need them for the prep stage per se, but when you're in there and you're on your feet, it's always good to have a second opinion.
And that applies obviously to both trials and appeals, right?
That's right.
Okay. And and in these cases, so but are there cases where, for example, have you had situations with Ashley where she wanted to take on a case and you didn't want to take it, or um, where you, I mean, there must
Yeah,
have,
we do, but it's mostly it's not perhaps what you're thinking. It's like some family member gets some sort of ticket or something, and they
okay,
call her because she's younger. So the younger cousins will call her, and and maybe it's above her head, or maybe it's a criminal thing and it's above her head, and she's like, "Can you do it?" I'm like, "I don't want to do it." Right? So you do it, or you deal with them, or like it'll be a friend from law school referral. She wants to help them out, but it's basically we have to do it pro bono. And I'm like, okay, if you want to do it pro bono, you do it, Ashley. Like it's not going to be the two of
yeah.
us. We'll get into disagreements about that, but otherwise, no, it's pretty simple.
Okay, and you guys take on any criminal case, right? You don't have a specific niche area that you focus on, that it has to be only sex assault cases or only drug cases. You do pretty much everything.
That's right. We do everything.
Okay. All right.
Yeah.
Well, Chris, I know that you have limited time, so I don't want to take much of your time, but I wanted to say thank you so much for sharing your approach to appeals. I know a lot of people are really interested and curious to know how does Chris Sewrattan work on his appeals. So it was very nice to hear from you and very nice to see you.
Yeah.
And hopefully we can have you back again to talk more about whether it's more about appeals or about something else, but it's nice to see you on this show.
Always nice to see you, Maya. And I do want to leave everyone with this. If it's more junior members of the bar watching this,
Mhm.
a lot of people know me from used to be on Twitter and now I'm on Blue Sky. But the point is, I summarize judgments. I would recommend to any junior lawyer in Ontario to read the Court of Appeal every single day. It's daunting and difficult, but it will quickly become habit. And in about 2 years, you can learn everything there is to know about criminal law in Canada by reading the Court of Appeal. So do
And
it, it will pay
yeah,
dividends in the future.
yeah. And that's really very good advice. And if you don't want to read the full thing, you can at least follow Chris on social media, and you can read what he writes. I mean, that's what I do. It's like I follow you and I read what you write. And, like it's also a good shortcut
Yeah.
sometimes to things. So thank you again, Chris. And it's very nice to see you.
Nice to see you as well. Take care.